is our civil number 1905544. Some preliminary matters to start with. For members of the public, including any clients who may be attending this argument, please do a variety of things. First of all, mute your computer so that you do not speak during this proceeding. And secondly, turn off your camera or block your camera in some fashion so that you're not on the screen. We are recording this oral argument, and as I said, everybody except the three judges should mute their microphones, and that goes for the counsel who are arguing when they are not speaking. So each side will have 20 minutes within which to present their argument in this matter. Appellant may reserve some portion of that for rebuttal. And I will be keeping track of the time, and we'll try and give you a heads up, Mr. Frazier. If you tell me how much time you wish to reserve for rebuttal, I'll try and give you a heads up on that. We have read the briefs. We have conferenced the case. We're familiar, I believe, with the underlying facts relevant to the issues raised and the entire record. And we conferenced this case today as well. So with that, Mr. Frazier, you may proceed.
First of all, Your Honor, can you hear me and see me? I just want to make sure everything's working.
Yes, we can see you and hear you.
May it please the court, my name is Eric Frazier, and I represent the appellant JAI Dining Services. I'd like to reserve about 5 minutes of my time for rebuttal. Your Honors, there has to be a limit on the scope of a bar's liability, and there are three different ways to define that limit in this case. I'd like to start first with preemption, and I will address the waiver issue first. We did not raise preemption below, but this is a classic case considering the issue anyway. The case law on dram shop liability is a mess, and this court should help straighten it out. This case has the perfect posture for revisiting the Young versus DFW case. Preemption is outcome determinative because of the jury verdict. And the Superior Court would have been completely powerless to do anything with Young versus DFW because it was binding on the Superior Court. The facts are clean. This is a pure question of law. It is a constitutional issue. It affects an entire industry, and it fundamentally affects the legislature's power. We ask that you consider the issue of preemption, even though it was not raised below. Young versus DFW is wrong, and it is time to take the case off the books. The Arizona Supreme Court clarified the scope of the anti-abrogation clause in Dickey. The test announced in Dickey is whether a suit could not have been maintained at the time the anti-abrogation provision was instituted, meaning 1912. Young is inconsistent with Dickey. It is from an earlier era of anti-abrogation precedent. Here, just like in Dickey, there was no liability at common law. That means that the legislature can legislate because it does not affect a claim that was viable at common law. The claim did not evolve from the common law. Ontiveros rejected the common law, just like in the cases leading up to Dickey. The court created new liability where there was none before. And if you look at the modern anti-abrogation cases, especially beginning with Dickey, creating new liability, the courts creating new liability does not prevent the legislature from determining the scope of that liability. JAI won on the only claim that was not preempted by the legislature. And this, Your Honors, is actually a little bit simpler than what we laid out in the briefs. The simple version is this, and it's all you need. Claims 1 and 3 do not require obvious intoxication. The legislature has preempted all claims except those in 4.311. 311 requires obvious intoxication. So claim 2 is consistent with the non-preempted claim. Claims 1 and 3 are not consistent with section 4.311, which means they're preempted by 4.312. So I know the briefs went into great detail about what the jury necessarily found, but it's much simpler than that. You just have to look at which claims are consistent with 312 and 311. Claim 2 is consistent, claims 1 and 3 are not, they're preempted. The court should take Young versus DFW off the books because, again, it reflects an earlier era of anti-aggregation precedent. The second way to define the limit of a bar's liability, Your Honors, is intervening superseding cause. And this is a question for the court when the facts are not in dispute. Proximate causation is a very complicated concept because it can involve fact questions. It can involve questions of law. It can involve questions of public policy. Here, only one fact matters, and it is undisputed. The undisputed fact is that Caesar got to his own home and into his own bed before deciding to drive again. Under Patterson and under the Anderson versus Matador case, which is of course unpublished, that means no liability as a matter of law with no role for the jury. This is an important issue, and we ask that you publish your decision in this case. We are not in the Dupre versus JAI territory because there is no question here that Caesar reached his own house and got into his own bed. No reasonable jury could conclude anything other than that is a place of repose where we expect him to stay. The Patterson standard, which was then again applied in the Anderson versus Matador case, makes perfect sense. The central risk that we're concerned about in dram shop cases is about getting people home safely from the bar. We know that people don't.
Mr. Frazier, so in this case, the jury was instructed on intervening cause, wasn't it?
It was.
And so your argument is that on these facts, the jury should not have been allowed to determine whether to find an intervening cause.
That's right, because this is a question that the court can rule on as a matter of law. That's what the court did in the Patterson case, what the court did in the Anderson case. There was no fact question to send to the jury. In the Dupre case, the court suggested that the only thing that the jury needed to do was find out whether this person who lived at his car was expected to stay the night at his girlfriend's house when he slept in his car. That's a fact question. Here, there's no legitimate role for the jury. If there were a legitimate role for the jury, the court should have sent both Patterson and Anderson to trial, whereas this court affirmed the grant of summary judgment, meaning that this is a question of law for the court. Proximate cause involves the court setting the outer bounds of a bar's liability. This outer bound makes sense, again, because the central risk to be avoided in dram shop cases is that trip from the tavern to the patron's home or wherever the patron's going to sleep for the night, whether it's a hotel room or his own home, that first leg. Once the patron is home, that risk has been avoided. At that point, the patron presents the same risk to the public as somebody who drank alcohol in his own home, as somebody who took an Uber home, as somebody who walked home, who had a designated driver, whether voluntarily or required by the bar. Once the patron is home, they present the same risk to the public.
And so counsel, would you say that's the case regardless of the length of time the patron is home?
Yes, I think that is a bright line rule that once you reach home, first of all, the bar's ability to do anything about it stops at that point. Once you're home, the bar can't put security guards at your house, can't boot your car, do anything like that, can't prevent you from doing anything once you're home.
Aren't there some cases that might come outside of that? For example, if the bar is aware that the patron is leaving intoxicated, getting in his vehicle and says, I'm going to swing by my house, pick up more alcohol, and I'm on my way somewhere else.
Yes, Your Honor.
Is the fact that the patron arrives at home and touches home base, is the bar scot-free then?
So we said this in our very first brief in this case. In the opening brief, we admitted that if the bar has specific knowledge, that can negate the intervening superseding cause because it makes the later conduct foreseeable. But without specific knowledge or anything to put the bar on notice that the patron might drive again or might decide to drive after reaching home, then that is a bright line rule that this court out.
Is that a passive duty, Mr. Frazier, or does the bar have an an affirmative obligation to inquire as to whether an intoxicated patron intends to be operating a motor vehicle later on in the evening.
So that takes us into duty, where the bar, no case has ever held that the bar has an obligation to inquire. No case has ever held that the bar has an obligation to provide any kind of transportation home or ensure that the patron gets transported home. The limit of the bar's duty is not to serve an obviously intoxicated patron, which we know the jury here found the bar did not. So the bar does not have an affirmative duty to ask questions about the patrons. Again, the proximate cause analysis assumes that there is negligence. It assumes that the bar has breached this duty. It cuts off negligence.
With regard to the supervening cause, here there really isn't any evidence to support it. In fact, the only reason he drove was because someone came to him later, his girlfriend, and said, "You need to drive." Is that fair, that it wasn't something that was even contemplated when they left the bar based on the evidence we have?
That's right. I think based on the evidence we have, everyone expected him to stay home. He got into bed. I don't think he would have gotten into bed if he expected his girlfriend to wake him up and ask him to drive her friend home.
And in particular, as he's leaving the bar.
Right, exactly.
Does it make a difference that he actually got in his car and drove from the bar?
It doesn't, because again, once the patron has reached his or her own home, or wherever he's expected to stay for the night, he poses the exact same risk to the general public. So whether he drove home, and in this case, thank heaven, he made it home safely, or whether he did the right thing and called an Uber or had a designated driver, or whether the bar called a taxi for him. In all of those situations, once the patron has made it home, he poses the same risk to the public. And the later decision to drive is the event that triggers the proximate cause analysis. It's the intervening superseding cause.
And just so we don't confuse things any further, intentionally or otherwise, and I appreciate that we are not talking about duty when we talk about causation. It's your position, I guess, that the concept of force is not part of proximate causation analysis.
I'm sorry, there was a noise when you were speaking. Yes. I couldn't hear you.
I'm guessing that the concept of foreseeability is not part of the analysis here of intervening cause.
Well, foreseeability is part of the general standard for a superseding cause. And so Patterson and Anderson have ruled as a matter of law that a patron's decision to get back into a car and drive is unforeseeable. So foreseeability is part of the intervening superseding cause analysis.
And
so that's a question that here, I'm sorry, yes, Judge Cruz?
Appellants propose that the jury impliedly found that Villanueva was not disorderly or obviously intoxicated, but couldn't the jury's verdict for JAI on the negligence per se claim be interpreted to mean that perhaps the bar did not serve, sell, or furnish liquor to a disorderly or obviously intoxicated person, because at the moment, Villanueva was not in that state, but that doesn't necessarily mean that he wasn't at the time that he left the bar. In other words, he may not have purchased anymore, but there's evidence of record that he did consume even after he stopped purchasing. So isn't it possible that that's what the jury verdict means as to the negligence per se claim?
So yes, but the only duty that the law imposes on the bar is not to serve or sell somebody who is obviously intoxicated. And there are lots of good reasons why that is, because otherwise you'd have to monitor the people as they're drinking. And again, the law imposes a limit on how much alcohol you can give to somebody at one time. So it's not as if you can serve somebody who's not obviously intoxicated and drop 15 old fashions on their table and walk away. The law imposes a maximum limit. It's measured in ounces, but it's essentially 2 drinks at a time. And so even though somebody who's right on the borderline before they're obviously intoxicated, a bar can serve them, even if it will take them over that limit. But you're not going to take them very far over that limit because of the limit on how much you can serve them at one time. this is part of Arizona's comprehensive regulatory regime for bars. So I want to make that very clear because it can be a little confusing in the briefing. ARS 4244, that is the comprehensive regulatory scheme on bars. And if you just skim through that section, that covers serving underage minors. It covers serving people who are obviously intoxicated or disorderly. It covers how many drinks you can give at a time, training, all sorts of things. There's a comprehensive regulatory regime that sets out what bars are supposed to do. We all know this is a very, very heavily regulated industry. Then there's a different part of the statutes, the 4311 and 4312. That concerns the private causes of action. But for duty, I want to make clear, I mean, we can look at any of them, but the most relevant thing to look at for duty is 4244. That's the regulatory regime that the legislature imposes on bars. And both 4244, so the comprehensive regulatory regime, and 4311, both of them have the obvious intoxication requirement. And both of them frame it not in terms of, is there an obviously intoxicated patron at the bar? Instead frame it as, are you serving somebody or are you selling alcohol to somebody who already is intoxicated? I think we have to respect the legislature's choice on that matter, and it makes sense. The only other place this is relevant is once there is somebody who's obviously intoxicated, the bar has to kick them out. And that's under 4244 again. And the bar can let them stay on the premises for half an hour, but other than that, they've got to go. But there's no other duty that the law imposes on bars to somebody who's obviously intoxicated.
Mr. Frazier, you got 5 minutes, 8 seconds.
All right, I'll reserve the rest of my time for rebuttal. Thank you, Your Honors. And if it's okay with you, I'll turn off my video so it's not distracting.
That's fine. That's your choice. All right. Mr. Abney, good morning.
Good morning, Your Honor. Or
good afternoon, rather. I'm sorry.
May I proceed, Your Honor?
Yes, you may.
My name is David Abney, and I'm appearing on behalf of the plaintiffs' appellees for a change. The intervening superseding cause thing is really very difficult. It's complex, it's hard, there's a lot of facts involved in it. My colleague suggested that as a matter, in his argument, that this court had ruled as a matter of law in Patterson that there was no intervening and superseding cause, and I take exception to that. I think what this court did in Patterson was to look at the very unusual facts and say, in this particular case, there is the intervening and superseding cause. You have this obviously intoxicated patron. She had backed her vehicle into a parked Jeep, and then she ran over a parking block. Then they confiscated her keys, called a taxi for her, which never arrived. But one of the employees of the tavern went over and beyond the call of duty and drove her to her home, leaving her vehicle at the tavern, and she's at her home. And then the only thing that I'd say they really did wrong was to give the keys back to her. But they gave the keys back, and I think never expecting that she would find her way back to the tavern, get in the car, drive the wrong way down a busy street, and crash into another vehicle. That was just beyond what anybody could have reasonably expected. And as a result, based on the facts, I believe that this court decided that that was an intervening and superseding cause. But here we don't have the same situation. We've got Villanueva, who's given the bum's rush out of the bar because he's acting disorderly and obstreperous. The employees watch him drive away in his own truck. And as you go through the testimony at trial, well, Villanueva said, well, I was drunk after we got the first mega bucket. Mega bucket had 15 bottles of beer. My colleague suggests, well, there's limits on how much you can serve one patron. It's 40 ounces of beer, a liter of wine, a 4-ounce drink of hard liquor. But here they dump this big bucket on the table. Who knows how many beers he had out of this big bucket? And then he has more of another bucket. And by the time he's leaving, he said he was drunk after the first mega bucket. Drunk, and he knew it. When he was thrown out, he admitted he was drunk. When he drove away, he admitted he was drunk. When he left his brother's house to go to his own home, he admitted he was drunk. When he agreed to drive Wendy home, the next to final leg of his journey that morning, he admitted he was still impaired. When he was driving from Wendy's home to the site where the accident happened, he admitted he was impaired. And then to the police officers, after it was all done, he admitted he was impaired. And the police officers looked at him and their testimony was, yeah, he was impaired, visibly impaired, no question, bloodshot eyes, failing tests, nystagmus test, everything. But he was impaired all the way through and admitted it. This is not the same as the situation in Patterson. I believe Judge Cruz asked about, well, what about regardless of the length of time? I think that matters a lot. Suppose he had driven 5 minutes to his home, laid down on the bed for 5 minutes, and got up and started driving around town. Well, who cares that he reached what my colleague loves to describe as a place of repose? That's really unimportant. Or a place where he's going to sleep for the night. Well, he didn't sleep for the night. The other side is looking at this through the wrong end of the telescope. They're looking at it from the sense of foresight. What should they foresee? What you do when you're dealing with an intervening and superseding cause, and all the Arizona cases that talk about this and go into depth say, it has to be something that's both extraordinary and unforeseeable with the benefit of hindsight. With the benefit of hindsight, there's nothing so extraordinary about somebody with such a high blood alcohol content who admits throughout that he was drunk and impaired in having an accident a few hours after he leaves the bar. And if he may stop at his own home and lie down for a few minutes, so what? This reaching a place of repose, it's a nice phrase, but it doesn't really help us in the analysis. Could reasonable.
But in this case, don't we have more than that, counsel? Don't we have more than just stopping by, as I asked of opposing counsel? We have someone who goes to another location, then eventually ends up at home and goes to bed for not a few minutes, but I believe the record says close to an hour or around an hour. Was it really? Is that what the record reflects?
I don't think it's that long a length of time though. But he was. I'm sure my colleague will correct me. But he was in bed for a while and then gets up and goes. But all this time, I think you need to look at this not in the sense of well, can the bar foresee this at the start? Can the bar control what he's doing at the start? You have to look at it from the back. Well, looking at this in hindsight, is it foreseeable, reasonably foreseeable, and not extraordinary? But this sort of thing would have happened with somebody who was so intensely intoxicated that he admits throughout that he was either drunk or impaired. Is that extraordinary and unforeseeable? It's something it really needs to get to the jury. It's a very intense facts question. I submit, and I hope one of these days the Supreme Court will toss out this whole intervening superseding cause nonsense, because it doesn't work with comparative fault. When you think about it, what sense does it make to say,
Mr. Abney, it sounds to me,
another day.
Mr. Abney, it sounds to me like you're really wanting to argue the question of duty and breach of duty as opposed to causation. And if in fact the role of the court is to set outer limits on causation, it seems to me that in Patterson and then in Anderson, this court did that. And I realize that a denial of a petition for review is not indicative of much, but I think in each of those cases, the Supreme Court declined review. So if we got it wrong, they had a chance to fix it there and they didn't. So I'm not sure that, well, I'd like to think we didn't get it wrong in Patterson for sure. And Anderson is actually a much better written decision. But be that as it may, where would you draw the line? Because if you don't draw the line, then everything's a fact question for the jury, which might fit into Justice Feldman's view of the world. But I don't think it fits with current jurisprudence.
Well, it may fit in with pure comparative fault. I mean, as a notion that these sorts of things really ought to be left to the jury at all times. But as far as Patterson, which is, by the way, brilliantly authored and well crafted, I think you have reached the edge. And I read that half the time I read it, I go, okay. Half the time I read it, I go, no. But it's just so strange. You read it, you go, this is just strange that somebody would do this, that they get safely home. All this care was taken, and for some reason she gets a bee in her bonnet and goes back to get her car, and then drives the wrong way down the road. Just, it's not something you would expect. It's extraordinary. It's unforeseeable. But here, what happened is not extraordinary.
But how is it different that a person intoxicated might grab their vehicle and not have the wherewithal to realize that they're going the wrong way, versus getting in their vehicle and not realize that the car in front of them is stopped and rear-ending it.
Well, the difference is
what's the difference? Isn't it, 6 of one, half a dozen of the other?
no. I think I got the math right. 6 on one side, 6 on the other. But
Intentional.
The problem being, what happened in Patterson was the tavern actually went to the extreme of separating her from the vehicle by miles. Vehicle's one place, she's in another place. Who would expect they get back together again right away? That's just beyond strange. But here you don't have that. Here you have a patron who's left the bar in his truck. He drives around, he stops at his home for a while, then he keeps driving, and he has this collision. This is not a case where he's separated from his vehicle and somehow they get back together again in a strange circumstance. This is really just a continuous sort of thing. There's a brief interruption at his place of repose, but I don't know, that doesn't matter. What matters is, could reasonable jurors looking at this decide, with the benefit of hindsight, that this is extraordinary, this is unforeseeable? And here the jurors said, no, this is not extraordinary, unforeseeable.
Mr. Abney, you keep saying it doesn't matter that he got to a place of repose, but don't the cases say once somebody gets to that place of repose, then what happens next is a supervening event? Because once you get home, our law says, all right, now you are in a different place. It's not a hotel room. It's not a parking lot in your car. You're home.
Well, you get to two very related problems. What's your condition physically, when you left the bar, when you get to your home, after you're at your home for a while, and then how long are you at your home? I don't think the Arizona cases have said a place of repose automatically cuts off liability and creates some sort of extraordinary and unforeseeable series of events. As I suggested earlier when I was talking about Judge Cruz's question, suppose he had simply driven home for 5 minutes, laid down for an hour, and then got up and driven away. What does it matter? Just because he gets to a certain place and maybe he wants to stay there for the night, but he doesn't stay there for the night. You got to look at this in hindsight. And if you look in hindsight, what's extraordinary about a person in this condition, leaving the bar a few hours later, causing this accident, even if he stops off at his own place or his girlfriend's place or his brother's house?
But aren't you arguing then that Patterson and Anderson also are wrong? Because with that argument, anything could happen. Because the person, if they're drunk enough, could decide they're going to do something. And the bar is on the hook from the way you're discussing it.
Well, as I suggested earlier, I'm ambivalent about Patterson, but I think overall that it hits the right balance. There's something so strange about the facts in Patterson that when you read it, you discuss it with other people, everybody shakes their heads and said, who would have thought she'd have done that? That's just bizarre. And reasonable jurors could have said, well, I think the way this court looked at it is reasonable jurors could not disagree is really the sort of approach. And here, reasonable jurors could disagree about whether he's liable or not, causation or not. They could fight about it in a jury room and reach one decision or the other. In this case, based upon what the facts they heard and evaluating the testimony and everybody's credibility, they decide, well, this is not so extraordinary and unforeseeable.
So what are the outer limits that the court should set in this case? What's the outer limit?
Well, we haven't reached the outer limit in this case.
What is it? What would have been the outer limit here?
Well, it's a combination of condition and time. A day clearly would be too much. You can't hold the bar liable a day, 24 hours. 12 hours, probably too much. 6 hours, probably too much. Now you're getting closer and closer to the events here, and I really don't know where to put that line. If it's physical condition, the amount of alcohol in his system, his amount of impairment, and the amount of time leaving the bar, we've hit a gray area in this case. And that matters because since it is a gray area, the jury gets to decide and not the judges and not the courts.
Well, counsel, are you really arguing that as long as he's still drunk, they should be responsible?
No.
Sounds like, when you start to use times and how much alcohol is still in the system, it seems that that's your argument.
No, it's part of the calculus, though. There's a lot going on here. What was his condition when he left? How much had he been drinking? How much alcohol was in his system? Doing retrograde analysis. How many stops did he make? What was his level of impairment throughout? And how much time? you have to, there's so many circumstances that go into a case like this, and that's what makes it so very hard to evaluate. Patterson was easier because you had this bizarre occurrence of her car, truck in one vehicle in one place, keys in another, keys with her. She's separated by a long distance. Nobody expects her to get together again with her vehicle, and she does.
But isn't it kind of odd that, he went to a friend's house, then somebody drove him back to his house, he went to bed, then someone woke him up, and then had someone else drive him to yet another place an hour away, and then he drove. I mean, we're getting, the same attenuation that you have in Patterson arguably is here. It's just a different way. But, do you really expect people to start shuffling around and moving around and friends driving places, people all over the place, and then ultimately he gets back in his own car and drives?
Well, I think that's another part of the analysis. I'd be at bed by 8:30 or 9. I wouldn't be at the bar at all. But these folks are out to party, and they're traveling around a friend's house. They're doing this, that, and the other. And their clock is so different from mine, it's hard for me to grasp what's going on most of the time. But they're out there active. He's moving around. He is a threat to the public, and as it turned out, a fatal threat to the public. But all that's just one of the threads in this fabric of what's going on here when you're talking about intervening and superseding cause. It's not.
So what could the bar have done to stop this? How could the bar have cut off its liability without committing kidnapping or grand theft auto or something short of that?
Well, in Patterson, they confiscated the keys. Not a bad idea if you could do it. Before I digress on things they might have done, I'm really talking about standard of care here. So a standard of care: confiscate the keys, call the police, disable the vehicle if possible, persuade his friends and relatives to make sure that he doesn't go anywhere. There's a range of things that the bar could do to satisfy.
So what happens? So what happens if they had done that? They said, nope, you, Mr. Villanueva, don't get to drive. You're too drunk, and someone who's with them who has not been drinking gets behind the wheel and drives him home. And then he gets home, he gets in bed, and at some point someone wakes him up, and off we go. We pick up with the same story that happened here from that point. Does the fact that someone else drove him from the bar originally to his home, that cuts off liability?
I think you get to the situation where Judge Winthrop will be writing Patterson 2. That what you're describing is more like the situation in Patterson, where the bar has gone above and beyond the call of duty to try to prevent things from happening. That would be something to consider as far as whether what happens is extraordinary and unforeseeable with the benefit of hindsight.
So, Mr. Abney, it sounds to me like what you're really arguing is that it matters how he gets home as opposed to the fact that he got home. So under your scenario, if he had taken an Uber from the bar to his house, then under your vision of causation as a fact question, Uber would be responsible if they simply dropped him off at the door and left and didn't take protective measures. The bar would still be on the hook, even though they called Uber. So, I understand your argument, but I'm just not sure it's any more workable or it's a better workable solution than what we've got in place here.
Well, what we've got in place here is Patterson at the outer edge of what makes sense as far as applying intervening and superseding cause. But in these cases, and I think this court was careful in Patterson, and it's careful in the other cases dealing with intervening and superseding cause, there is a whole lot going on.
So, counsel, is it your opinion that Anderson was wrongly decided? Because the Anderson's facts are very similar to this.
Well, Anderson not being precedent, I'd rather not discuss it a whole lot, but yeah, in general, Anderson would be somewhat questionable. But still, but Patterson is what
How
we
would
have
you
the primary
distinguish
indictment.
Anderson? How would you distinguish Anderson from the facts of this case that we would see it differently? I know it's not precedent.
What I would say about Anderson is we've got something here. Well, we've got several things here. One is strong evidence of the level of impairment and intoxication from experts, indicating very high level of blood alcohol when he left the bar. Strong evidence that he was disorderly. His continuing admissions that throughout this whole process, at every point where he's moving around, from the time that he starts drinking at the bar till he leaves the bar, till he goes to the friend's house, he leaves the friend's house, he goes every step along the way, he's admitting that he's drunk or impaired. So we have this constant theme of impairment and drunkenness. You don't have that in Anderson or even in Patterson. You just have sort of a hit and miss analysis in both cases, and hit and miss facts in both cases. Here you've got this incredible tapestry of facts as far as what happened. You don't have it in Anderson, you don't have it in Patterson, but here you've got a gentleman who was really gone, and he stays gone through this whole episode, this whole tragedy, every step of the way. He himself is admitting he's drunk and impaired, and I think that's a fundamental difference here. But again, I submit to the court that when you're dealing with cases like this, there is no simple answer. Until you get to the extremes, until we get to 24 hours or 12 hours or 6 hours, or until we get to this bizarre situation in Patterson where the vehicle and the patron are separated by miles and miles, and they somehow get together again. Until we get to
if we accept your argument, don't we then have to address the constitutional issue?
You mean Article 18, Section 5? I know what you're
By the issue, the preemption issue, which is a statutory issue.
Well, I think I addressed that pretty well in the answering brief, but you've got a series of cases: Brannigan, Ontiveros, Hernandez, Petalicio, Dupre, Patterson, and Henning. All of them say the same thing, that you can have the common law and the statutory law violations at the same time. The common law, of course, you get into that discussion that you at the courthouse probably have once in a while. Where does the common law come from? Is it something that we discover? Has it always been there? When we say that there's an advance in the common law, aren't we just going back to common law principles that already existed? When you talk about the early cases, Brannigan, Ontiveros, Hernandez, Petalicio, they were founded on a very simple idea that if you give a dangerous instrumentality, whether it's a gun to a child or a vehicle to someone who was incompetent to drive that vehicle, then you have violated the duty that's owed to the public. And they were very strong in that. We're simply taking those existing common law principles and moving them forward in time to our present social situation. Where we have
1 minute, Mr. Abney.
Okay. So I do not think that even if you got to this preemption thing, the Arizona Supreme Court and this court have repeatedly said that the common law and statutory law work together, and they should work together. This is a terrible problem, and I hope that you will find that they are consistent. There's been no preemption. As far as extraordinary and unforeseeable, what happened here, if you look at the total fabric of the situation, was neither extraordinary nor unforeseeable. It was sadly predictable. Thank you, Your Honor.
Thank you, Mr. Abney. Mr. Frazier.
Can you hear me and see me again?
Yes, we can.
Great, thank you. So a lot of these discussions inevitably end up circling back to duty, which is why I want to take one more run at the anti-abrogation issue, because Judge Winthrop, you mentioned Justice Feldman, and Young was decided in 1995 at the height of the Justice Feldman era. Justice Feldman's view of the anti-abrogation clause was controversial at the time. Almost every one of those decisions in the early days have concurring opinions, dissenting opinions, what have you. It was controversial when he was on the court. I think it's safe to say it's not the modern view from the Arizona Supreme Court. The controlling test from the Arizona Supreme Court in Dickey is whether the suit could not have been maintained at the time the anti-abrogation provision was instituted, meaning 1912. How can it be the case that a claim that would have been totally barred at common law is subject to the anti-abrogation clause, especially when you think about the timeline here? We know dram shop liability didn't exist at common law in 1912. Ontiveros rejected that common law. The legislature acted within just a couple of years. And I'm struggling to see how it can be unconstitutional for the legislature to essentially codify Ontiveros, which is really what they were trying to do here, and preempt other common law claims to bring clarity to this area. So we don't have this mess of common law claims, statutory claims, when it's almost impossible to articulate what the precise duty is, when this is one of the most regulated industries out there. There's a very comprehensive regulatory regime that says what bars can and can't do. The bar is under no duty to take away your keys, impound your car. In fact, I think they wouldn't have legal authority to do most of those things anyway. Mr. Abney repeatedly talked about how Caesar admitted that he was impaired or drunk. Those are not the same things as obvious intoxication. The jury heard lots of evidence from witnesses, from expert witnesses, lay witnesses, that Caesar was not obviously intoxicated. We said in our brief, there is a big difference between somebody who is impaired and cannot legally drive versus somebody who is obviously intoxicated. It makes sense to say that when someone is impaired, we don't let them drive, but they are coherent enough that they can make that decision on their own of whether they need to call an Uber versus, so we place personal responsibility on them at that point. Versus when somebody is so obviously intoxicated, and if you look at the statutory definition for what that means, it means obvious physical signs or obvious, mental impairments. That's when we impose liability on the bar, because that's what the bar can control, obvious intoxication. Mr. Abney also talked about the affirmative steps that the bar took in Patterson and speculation about other affirmative steps. Those were relevant to duty, not proximate cause. That's what how the Patterson decision talked about them. Anderson confirmed that those are relevant to duty, not proximate cause. When we get to proximate cause, we assume that you've already breached a duty imposed on you. The line here is in intervening superseding cause is not about how long the patron stays home. The line is, does he get home? Does he get to a place where he should stay home and sleep it off? Once you're home, you stay home and you sleep it off. The place of repose concept that we coined is really to distinguish times when you get home and we expect that you'll stay home versus an intermediate step along the way, stopping for gas, stopping at McDonald's. Those types of things do not cut off liability, but reaching your own home and getting into your own bed, that is a question the court can answer as a matter of law, both as a matter of law in Patterson and using this court's power to set public policy. When you read, we've all read Prosser and Keaton many, many times on some of these issues. And that's the theme you see from Prosser and Keaton. Proximate cause is largely about setting public policy. It's saying an actor did something negligent, and now we're going to say, what are the limits to the liability for the harm that occurred? We have to impose some limits as a matter of public policy. And that is a workable, sensible limit that makes sure the bar is not liable for what happens the next day, which Mr. Abney conceded it wouldn't be. It's time to clean up the law in both intervening superseding cause, duty, and I think most of all, abrogation and preemption. The easiest way to do that is to get Young versus DFW off the books and confirm the scope of the duty once and for all. Again, this is a comprehensive regulatory scheme that the legislature has imposed, and we should respect that.
All right, thank you, Mr. Frazier.
Thank you.
We appreciate the briefing and arguments presented by counsel here today. We're going to take this matter under advisement. We will issue a written decision in due course. With that, we are adjourned.
Thank you, Your Honor.
Thank you.